I'm Melvin L. Raymond, attorney and counselor at law. Welcome to Raymond Law Live. First, I want to give a shout out to Better Family Life Outreach and the Sims and Bailey law firm. Better Family Life has their Kwanzaa Expo on December the 16th and 17th. Please call them at area code 314-367-3440, extension 715 for more information. You can also get more information about the expo at www.betterfamilylife.org. Sims and Bailey is a Central West End law firm providing quality legal services and expert representation. You can contact them at area code 314-534-0800. I hope that everyone had a great Thanksgiving holiday. As we enter the holiday season with Black Friday and Cyber Monday, we are looking forward to and getting close to the end of the year. Boy, how time flies. Now, on today's broadcast, we're going to start where we left off last week. You recall that our topic last week was wills and trusts. We covered wills. The topic for today will be trusts. If you want to add to our discussion with comments or questions, please post them and I will cover them at the question and answer segment of the broadcast. So let's get started with our topic for today, which is trusts. Some of you may be less familiar with trusts as opposed to wills, which we covered on the last broadcast. So what is a trust? A trust is an arrangement whereby property is transferred with the intention to be transferred by a creator, also called a settlor, settlor, with the intention that it be administered by a trustee for the benefit of a beneficiary. Therefore, a trust is a right of property held by one person or one party for the benefit of another. This is known in the law as an inter vivos trust, also commonly called a living trust. That's the common name for the kind of trust that we're going to be talking about on today's topic. Now, you should know that there are different categories of trusts, including private trusts and charitable trusts. And also a third category is various special purpose trusts, such as a business trust, a charitable trust, either public or non-public, which is devoted to a charitable purpose. One other category of trust that I want to mention is special needs trust. That's a special kind of trust for the benefit of disabled persons, either adult disabled persons or binary disabled persons. And what special needs trust does is it insulates from consideration the disabled person's assets for purposes of insulates the assets from consideration for Medicaid purposes, for instance. Now, there is with a special needs trust a payback provision which occurs at the end of the life of the disabled person. So we're going to be dealing today with so-called living trusts or special or inter vivos trusts. So living trust is going to be the topic that we are going to be dealing with today, as opposed to the other categories of trusts. Now, how is the trust created? A trust is created by a declaration of trust or a trust agreement and it takes effect during the lifetime of the settlor or the creator of the trust. Now, I'm going to be using settlor to refer to the person who creates the trust, and that is the person who would transfer assets into the trust. So the settlor creates the trust, and the trustee is the second party to the trust. The trustee actually holds title to the property for the benefit of the beneficiary. So the settlor is the first party. The trustee, who holds title to the assets of the trust and administers the trust, is the second party. And the third party is the beneficiary, who has a property right to the assets of the trust. So that's three parties. Now, there are two types of trusts. One is the living trust, of course, which is created and takes effect during the lifetime of the settlor. And the second type of trust is a testamentary trust, which is created in a will. A testamentary trust, again, is created in a will, and it may be funded as provided for in the will. Now, if you recall from our discussion last week, the will takes effect at death. So if there is a testamentary trust created in a will, then the testamentary trust, of course, would take effect at death of the settlor. So we're going to be talking mostly about living trusts as opposed to testamentary trusts. But all the formalities to create a testamentary trust are the same as creating a living trust. It's the only difference is that the testamentary trust, of course, takes effect at death. Now, when a trust is created, it usually involves the contemporaneous transfer of assets to the trust. And that's done again at the time of the creation of the trust. And the assets of the trust, sometimes referred to as the corpus of the trust, can be property or assets transferred to the trust by transfer on death, as with, for instance, vehicles, automobiles, or by a pay on death designation, which would apply for testamentary trusts. Any person of capacity, which means a person of sound mind, can create a trust. An 18-year-old person or a person under 18 years old can own property, and also a person under the age of 18 is considered legally a minor. That person can not only create a trust and be settlor, but they can also make contracts and be sued. Minors, however, cannot prosecute lawsuits. They have to have a person of legal majority, age 18 or older, to prosecute any lawsuits. So next friend would be how a person under 18 could prosecute any lawsuits, either involving a trust, a living trust, or any other kind of lawsuit. I mentioned that to create a trust, you have to have an intent by a settlor to transfer the property to be administered by a trustee. So as with most things in estate planning, you need the settlor's intent to create a trust, of course, and you need a definite beneficiary of the trust, unless the trust is a charitable trust or a trust, for instance, for the care of animals. Yes, there is in Missouri and many other jurisdictions, you can create a trust to provide for the care of an animal, believe it or not. And if such a trust is created for that purpose, you don't designate a beneficiary as such, but you're creating a trust to provide for the animal. And that trust, of course, would only be of duration during the lifetime of the animal. The trustee, of course, has to have duties to perform. And you should know also that the settlor could also be the trustee. But the trustee or the settlor can be the trustee, and frequently when trusts are created, and I'm familiar with writing and trust for clients, frequently the settlor is a trustee. Not always, but usually, more often than not, the settlor is also the trustee. There's only one thing that you can have: the settlor cannot be the sole trustee and the sole beneficiary. So again, the settlor, the creator of the trust, cannot be the sole trustee and the sole beneficiary. He can be a trustee, the settlor, but not the sole trustee and the sole beneficiary. Now, let's deal with the reasons that you may want to create a trust, or the principal benefits, if you will, of a trust. Send me your questions, which I will take at the end during the Q&A segment of the broadcast. Don't forget, so you can post your questions or your comments, and I will take those during the question and answer segment of the broadcast. The first reason or advantage to creating a trust is property management. The settlor can transfer property into the trust to be free of the burden of managing the trust. Free of the burden of managing the trust. And it also can be very helpful in the event that the settlor becomes incapacitated, or the trust can even be of duration past the end of the settlor's life. So even though a living trust can continue in effect after the settlor's death, if the trust declaration or the trust agreement so provides. You should know too that a trust also is used frequently as a financial planning for dependent minors and or dependent disabled individuals. And you can do a trust for financial planning for a minor or a disabled individual, either that would be an adult, in lieu of giving a gift to the disabled person or the minor. So that would be in lieu of an outright gift. And this would allow the settlor of the trust to have the trust principal paid only to the beneficiary in the case of a minor when that minor attains a certain age, or it could allow to fund certain designated uses for a disabled person. And one of the purposes for funding a trust for certain designated uses would be, for instance, for the support and maintenance of the settlor if he should become incapacitated. That's one designated use. It could be designated for educational purposes or for the maintenance of a minor. The third principal reason, in addition to property management and providing for disabled or minor individuals, is the avoidance of probate. So by transferring property into a revocable trust that continues after death, you can escape the need for probate administration and going to probate court for probate administration. Also, you should know that you can avoid the publicity that comes with probate administration. Probate states and probate proceedings are public proceedings, and the public can have access to certain documents regarding the estate that goes to probate. And the third principal benefit of creating a trust is tax savings. A trust can be an important vehicle for tax minimization. You would need to have a tax specialist to get into using the trust as a device for tax minimization. A trust can be set up for any lawful purpose, so long as the formalities of the trust, that is, creating the trust instrument and also funding the trust, so long as those are observed, then you can create a trust for any purpose. A trust can be revocable or irrevocable. Revocable, of course, means that the settlor of an inter vivos trust can change the terms of the trust or revoke the trust during his lifetime. Some trusts I've written for clients provide that the trust is revocable during the lifetime of the trust, but upon the death of the settlor, the trust becomes irrevocable. And in those situations, there is a co-trustee, another person in addition to the settlor, who is named as a trustee, and that trustee can continue with the trust after the death of the settlor. A trust can be short-term or long-term, and a trust can be terminated at any time. So if a settlor creates a trust, the trust can be terminated at any time. Just like you create the trust, you can terminate the trust. Most trusts provide for provisions for distribution of the settlor's estate at some point, either after the death of the beneficiary or upon some event in which case the trust would be terminated, and the assets or the corpus of the trust would be distributed. So those are some of the main points about trusts, living trusts or inter vivos trusts. Let me see if I have any. We're going to get in now into the question and answer segment of the broadcast, and I will see if I have any questions at this point. So we're going to take questions, or if you want to add to the discussion with a comment, then you can post your questions about trusts at this point. That's our topic for today. Or if you have a question about last week's topic, wills, I did get comments and questions last week about wills, then feel free to post your questions or comments at this time. This is the question and answer segment. So feel free to, at this point, to add to the discussion with your questions or comments. Trust, while I'm waiting for any questions or comments, is something that you typically need assistance with by an attorney. A trust can be a complicated document, and certain elements have to be there, and you need assistance usually. That would be very helpful to get assistance by an attorney in preparing a trust declaration or a trust agreement. And it's a very flexible instrument. You can include provisions in a trust, many different kinds of provisions, whatever you think would be helpful to you in planning your estate, in your financial planning. It's a very useful instrument, and you can deal with all of your estate in one document. After the trust is created, one of the things that has to be done, as I previously mentioned, is retitling your assets in the name of the trust. So, John Smith, if he creates a trust, John Smith is a settlor. He can become John Smith and own property as a trustee of the trust. He can't be the sole trustee, but he can be one trustee or a co-trustee, and he would own his property that he transfers. He has to retitle the property into the name of the trust, and that means for real estate, for instance, you have to transfer the property from John Smith to the John Smith Living Trust, dated November the 27th, 2018. And that's true for real estate. You do that with a deed. That's true for other accounts. If you have a bank account or an investment account, then the property has to be transferred from John Smith to John Smith as trustee of the John Smith Living or Revocable Trust. You can also retitle any other asset, investment accounts, bank accounts, stocks, bonds, and so on. You can transfer those assets also into a trust that you create, and that's a separate step that should be done, as I mentioned earlier, contemporaneously with the trust. The trust is not valid unless it has assets in it or a corpus. So it's very important that the trust has a corpus or assets in the trust. I have a question here. How does it work if someone has lots of insurance and there are verbal instructions as to the insurance? Now, I'm assuming you're talking about life insurance. Life insurance. Life insurance, usually people frequently designate a beneficiary on the life insurance policy, and that person would, at death of the insured, would get the proceeds of the insurance policy, the beneficiary. However, you can designate your estate as a beneficiary, or you can designate the trust as a beneficiary of the insurance policy. And if you designate the trust as the beneficiary of the policy, then the policy becomes an asset of the trust, and it would be subject to the terms of the trust. In some instances, I have seen clients who may want to fund a trust with the proceeds of a life insurance policy, and then if that's an asset, then it would be subject to the terms of the trust, and it would, of course, be administered by the trustee. There's a second question: are verbal promises enforceable? With respect to trusts as opposed to contracts and will, as opposed to contracts, for instance, a trust has to be evidenced by a written document called a trust agreement or a declaration of trust. And you have to, so it has to be in writing for it to be valid. There are certain formalities that have to be included or have to be present to create a living trust. And a verbal, that's not valid. A verbal trust would not be valid. It has to be in writing, and certain formalities have to be there. So no verbal trust, living trust can exist. And another question: how simple is it to create a trust? It is simple, and it's not simple. If you have assets, let's say your estate, your assets or your property is not too extensive, then it may be a little easier to create a trust. And you have to, it's a document if it's going to be effective as a financial planning device, and that's what you want to use it for, financial planning. So you need to think it through. Then it can get a little complicated and has certain elements, and you want to provide for the distribution, and keep in mind that its purpose is to benefit another person. A trust has a beneficiary. So whenever someone is thinking about a trust, then you need to sit down with an attorney who has experience with trust to discuss what your intentions are and what you are trying to accomplish with the trust as far as a financial planning device. So I would say it's not something that is very simple. It has to be thought through, and You need advice from an attorney about creation of a trust. And also, after it's created, the trust has to be administered. You want to think about that as well. The trustee should be someone, or is someone, who administers the trust, and they have to have the skills and ability to do that. I have another question. Is it a hard process, or can creation of a trust be tedious? Yes, it can, which is why you need you be well advised to get legal assistance with the trust, because it can be tedious, because not only do you have to prepare the declaration of trust or the trust agreement, but you also have to administer the trust, and it could be long-term or it could be short-term. So I would strongly recommend that you obtain legal assistance with a trust, because it can be tedious. Another aspect of it being tedious is the retitling of assets in the name of the trust. We are reaching our final segment. Thank you for your questions and comments. If you have further questions and comments, then you can reach us after the broadcast. In the last few minutes, I want to thank all of you watching this broadcast, and those of you who will watch the broadcast later for tuning in. I appreciate your time and your interaction. I hope this has you a little bit better informed about trusts. And I want also to give a final shout out to Better Family Life and their Kwanzaa Expo from December 16th and 17th. And their number for more information about that Kwanzaa Expo is 314-367-3440, extension 715, or www.betterfamilylife.org. And also, finally, the Sims and Bailey Law Firm, offering quality legal services and expert representation here in the Bi-State area. For contact information, area code 314-534-0800. Now, if you have further questions or comments, or want to contact us for personal representation for you or someone you care about, whoever, for instance, with assistance with trusts or wills or power of attorneys, then go to RaymondLawLive.com, or you can reach me on my Facebook page, facebook.com/RaymondLawLive, or Twitter @RaymondLawLive. And you could also call my office at area code 314-534-2800. Again, the office telephone number where you can reach me is area code 314-534-2800. And remember, see you next week at the same time, 6 p.m. Central. And remember, when you fight, know your rights.